Hello, everyone. Welcome back. Today, we're covering Public International Law for the 2025 bar with 30 essential questions and answers explained simply for quick review. Let's dive in. Question 1. What are the sources of public international law under Article 38 of the ICJ statute? Answer. The sources are 1. International conventions and treaties. Second, international custom or state practice plus opinio juris. Third, general principles of law recognized by civilized nations. And fourth, judicial decisions and teachings of publicists as subsidiary means. Key doctrine, pacta sunt servanda, which means treaties must be observed in good faith. Question 2. Distinguish the doctrines of incorporation and transformation in Philippine law. Answer. Incorporation doctrine. These are generally accepted principles of international law which automatically form part of the law of the land based on Article 2, Section 2, 1987 Constitution. Transformation doctrine, on the other hand, means a treaty becomes effective domestically only after legislative concurrence. This is based on the case of Coruda versus Halandoni, where the incorporation doctrine was upheld. Question 3. A foreign state entered into a purely commercial contract with a private Filipino firm. Can the state invoke sovereign immunity in case of suit? Answer. No. Under the restrictive theory of state immunity, immunity applies only to sovereign acts or hure imperi, and not to commercial acts or hure justonis. This is under the case of U.S. versus Ruiz. Question 4. Differentiate recognition of a state from recognition of a government. Answer. Recognition of a state means the acceptance that a political entity possesses statehood, which means there is permanent population, territory, government, and capacity for relations. On the other hand, recognition of a government means acceptance of a regime as the legitimate representative of a state. Question 5. When is Senate concurrence required for treaties in the Philippines? Answer. According to Article 7, Section 21 of the 1987 Constitution, it requires concurrence of 2/3 of all senators for treaties and international agreements. This is upheld in the case of Sagisag versus Executive Secretary, whereby EDCA was upheld as an executive agreement not requiring Senate concurrence. Question 6. What are the principles of state jurisdiction under international law? Answer. There are 5 principles. 1. Territoriality, meaning it is within its territory. Second, nationality, which is over its citizen and where. Third, protective principle, acts threatening security. Fourth, universality, universally condemn acts such as piracy and genocide. And fifth, passive personality, which is based on nationality of victim. Question 7. In extradition proceedings, is the extraditee entitled to due process? The answer is yes. The right to notice and opportunity to be heard applies even in extradition. Such is upheld in the case of Secretary of Justice versus Lanchon. Question 8. Differentiate asylum from extradition. Answer. Asylum is granting refuge to an individual, a discretionary act of a state, while extradition is a formal surrender of a fugitive to another state under a treaty. Question 9. State the maritime zones under UNCLOS. Answer: this includes internal waters where one has full sovereignty, territorial sea which included 12 nautical miles and subject to innocent passage, the contiguous zone which comprises 24 nautical miles and there is limited enforcement jurisdiction, the EEZ or Exclusive Economic Zone comprising 200 nautical miles and there is sovereign rights for resource use, the continental shelf which are rights over natural resources. These were upheld in the case of Magallona versus Ermita under the baseline law RA 9522. Question 10. What are the basic principles of international humanitarian law or IHL? Answer: basic principles include distinction between combatants and civilians, proportionality in terms of force use which must not exceed military advantage gained, necessity which means the use of force only when necessary, and humanity, the prohibition of unnecessary suffering. This is based on the law RA 985 Philippine Act on Crimes against International Humanitarian Law, Genocide, and Other Crimes against Humanity. Question 11. What crimes fall under the jurisdiction of the International Criminal Court? Answer: crimes include genocide, crimes against humanity, war crimes, and crime of aggression. This is based on Rome Statute of 1998. Question 12. What are the elements of statehood under the Montevideo Convention? Answer: there are 4 elements. Number 1, permanent population. 2, defined territory. 3, government. And 4th, capacity to enter into relations with other states. Question 13. What is the effect of non-recognition of a state or government? Answer: when there is non-recognition, this means that no diplomatic relations may be established, no capacity to sue or be sued in domestic courts, and there is inability to enter binding treaties with the recognizing state. Question 14. Explain the principle of sovereign equality of states. Answer: this means all states, regardless of size or power, enjoy equal rights and obligations under international law. They possess full sovereignty within their territory. Question 15. What is the difference between customary international law and treaty law? Answer: customary international law arises from general and consistent state practice accepted as law, or we call this the opinio juris. On the other hand, treaty law arises from formal written agreements between states governed by international law. Question 16. What are the modes of terminating treaties? Answer: there are 6 modes. 1, expiration of term. 2, fulfillment of the purpose. 3, mutual consent of parties involved. 4, material breach. 5, supervening impossibility of performance. And 6, we call this the rebus sic stantibus, which means there is a fundamental change of circumstances. Question 17. What are the grounds when a treaty may be declared invalid? Answer: treaties can be declared invalid if there is 1, lack of capacity of representative, 2, presence of error, fraud, corruption, coercion, and 3rd, when there is violation of jus cogens or the peremptory norm of international law. Question 18. What is jus cogens in international law? Answer: whose cogence refers to peremptory norms accepted by the international community as norms from which no derogation is permitted. So examples of these are prohibitions against genocide, slavery, torture, piracy. Question 19. What is the doctrine of rebus sic stantibus? Answer. This doctrine of rebus sic stantibus means that a treaty may be terminated or suspended if there is a fundamental change of circumstances not foreseen by the parties that radically transforms the obligations. Question 20. Differentiate absolute immunity from restrictive immunity of states. Answer. Absolute immunity means that state cannot be sued without consent in all cases, while restrictive immunity means the state is immune only for sovereign acts or hure imperi, but not for commercial acts or hure justonis. This was upheld under the case of U.S. versus Ruiz. Question 21. What are the immunities of diplomatic agents under the Vienna Convention on Diplomatic Relations? Answer. Diplomatic agents are immune from first, personal inviolability, meaning they cannot be arrested or detained. Second, they have immunity from criminal jurisdiction. Third, immunity from civil and administrative jurisdiction, but these are with exceptions. And fourth, inviolability of premises, property, and archives. Question 22. What is the principle of non-intervention? Answer. This means that states are prohibited from intervening in the internal or external affairs of another state. This flows from sovereignty and equality of states. Question 23. What are the categories of combatants under international humanitarian law? Answer. We have 1. Lawful combatants. These are those entitled to prisoner of war or POW status. And second, the unlawful combatants. These are those who are not entitled to prisoner of war status, yet they are still protected by fundamental human rights. Question 24. Differentiate neutrality from non-alignment. Answer. In neutrality, it means the legal status during armed conflict where a state refrains from participation and grants equal treatment to the belligerents, while non-alignment means that it is a political policy of not aligning with military blocs, such as those non-aligned movements during the Cold War. Question 25. What is the archipelagic doctrine and how is it applied in the Philippines? Answer. Under UNCLOS, an archipelagic state may draw straight baselines connecting the outermost islands, and the waters enclosed are considered archipelagic waters. So for Philippines, it adopted in Republic Act 9522, which we call the Philippine Baselines Law, and this was upheld in the case of Magallona versus Ermita. Question 26. Distinguish asylum from refugee status. Answer. An asylum is one who seeks protection and granted by a state to a foreign national against his or her own state, while a refugee status is a recognition under the 1951 Refugee Convention and UNHCR or United Nations High Commissioner for Refugees, and such recognition is based on well-founded fear of persecution. Question 27. When can universal jurisdiction be invoked? Answer. Universal jurisdiction applies to crimes so grave that any state may prosecute regardless of where it is committed or what nationality are of the perpetrators or victims. So example to these are crimes like piracy, genocide, crimes against humanity, and war crimes. Question 28. What are the modes of acquiring territory under international law? Answer. There are 5 modes. 1. By occupation or terra nullius. Second, by prescription, which means peaceful, continuous control. Or by cessation, through a treaty. Or fourth, through accretion, which is the natural processes. And the last, by conquest, although this is no longer valid due to UN Charter prohibition. Question 29. What is the doctrine of auto-limitation? Answer. A state, by consent, may voluntarily limit the exercise of its sovereignty, such as by entering treaties or joining international organizations. Question 30. How does the Philippines implement international humanitarian law domestically? Answer. Philippines implement this humanitarian law domestically through RA 9851 or the Philippine Act on Crimes Against International Humanitarian Law, Genocide, and Other Crimes Against Humanity, which criminalizes war crimes, genocides, and crimes against humanity in domestic courts. So, and that concludes our 30 essential Q&A in public international law. So if you found this lecture substantial and helpful, please don't forget to like, share, and subscribe to the channel. Daghang salamat.